The Honorable, the Chief Justice and the Associate Justices of the Supreme Court of the United States. Oh, yea, oh, yea, oh, yea. All persons having business before the Honorable, the Supreme Court of the United States are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court.
We will now hear argument in Mahanoy Area School District versus BL. Attorney Paolini and Attorney Mosin.
Mr. Chief Justice, and may it please the court. I am here representing Mahanoy Area School District in the argument of whether the Tinker Standard, which holds that public school officials may regulate speech that would materially and substantially disrupt the work and discipline of the school, applies to student speech that occurs off campus. BL was a student at Mahanoy Area School when she was suspended from the junior varsity cheerleading team for speech that occurred off campus but caused a disruption to the cheerleading team and the school environment. The Third Circuit ruled that the Tinker Standard does not apply to off-campus speech. The court should reverse the lower court's decision for the following two reasons. Firstly, the First Amendment does not bar schools from regulating off-campus speech when it is directed at campus and is substantially disruptive. The Tinker ruling does not require location as a standard, nor should it. The basis for regulating speech is on its significant harm to the campus community, not where the speech occurred. Second, abrogating Tinker for off-campus speech risks serious consequences, particularly for public education within the United States. The decision would overturn the rulings of the Pennsylvania Supreme Court and 5 circuit courts that represent a majority of the nation's public schools, public school teachers, and public school children. It would also undermine a variety of state and federal laws and school district policies that encourage or even require the regulation of off-campus speech. Furthermore, it would take away the control school officials have over their school systems in a world where the distinction between on and off-campus speech is growing increasingly blurry.
And now we will proceed to the factual backgrounds of the case. BL made the junior varsity cheerleading team as a rising sophomore, although she had been hoping to make the varsity cheerleading squad. At the same time, a rising freshman made the varsity squad, skipping junior varsity entirely. BL was visibly upset when the results of the tryouts were announced. The day after tryouts, she held the following text conversation with her coach. She said, quote, "Do you have to do a year of JV before you could make varsity?" Unquote. The coach replied, "No." BL
Attorneys,
quote,
as you have stated in your argument, Tinker v. Des Moines established that schools can, and I quote, constitutionally discipline student speech that risks significantly harming the campus community. How would BL's seemingly non-threatening snap and interaction on social media lead to material harm on the school's campus?
The key to that answer here is to the disruption that her speech had on the school environment the following week. So first, we should discuss what the messages were to explain how they infected the school environment. So she posted 2 messages on her Snapchat account, which is a social media site. The messages were visible for 24 hours, and they were visible to 250 users on the site, including a lot of classmates at her high school and a huge portion of the cheerleading team. So the first photo was an image of her and a classmate with their middle fingers raised at the camera. The caption was F school, F softball, F cheer, F everything. Notice how this speech directly addresses the school and the athletics department at the school, specifically the cheerleading team.
Attorney Paolini,
yes.
Coach Nicole Lucetta Rump, who's the cheerleading coach, stated in a statement that she punished BL, and I quote directly, for profanely referring to cheerleading and not because of any possibility of disruption. How then does this snap pose disruption on campus? mind that it is in an entirely different location and time than the said disruption later on.
Well, the key was in that the messages the following week repeatedly brought up to cheerleading coaches and by both members of the cheerleading team and by other students at the school. They repeatedly expressed their concerns about her remaining on the team.
Well, to extend your line of reasoning here,
right.
The message that we're discussing specifically was posted on Snapchat.
Yes.
Had BL in the same spot where the photo was taken, whispered to her friend the exact same thing, if her same words had also been discussed in the same disruptive capacity that you would say this message had, would that still be punishable?
No, if it was just to one of her friends and it was not to 250 people, mainly students and mainly members of the cheerleading team, because it would not have had the same harm on campus, it should not have been responded to in the same way by the school district.
What if the social media account was completely invisible to other students or cheerleaders?
If no one had seen the messages other than maybe a handful of people were not affiliated with the school district, no, it would not have had the same on-campus harm. And since the Tinker Standard, the basis for the Tinker Standard is the harm to the school campus and the school environment rather than where the speech takes place.
Do students surrender their First Amendment right just because they log on to their personal social media?
No, when a student is to have speech that is directed at the school environment, directed at athletics, the athletic department, and has a sufficient nexus to the school in which it affects the school the following week, it affects how classmates, whether they feel comfortable around her, it affects whether her teammates feel comfortable around her, then that student does not have the same First Amendment rights.
You mentioned that the Snapchat that BL posted directly attacked the school environment and her club, but there was no mention of the school district, of the name of the school, of any of the names of the coaches, but rather was a general statement, F this, F that. In the Cohen versus California case of 1971, the precedent was set that the use of the F word as a form of symbolic speech could not be considered fighting words and could not be regulated because in this case, it wasn't directed at any particular recipient. Is this not the same case in the BL versus Mahanoy case?
Right, so first of all, BL has conceded that viewers would understand she was referring to Mahanoy Area High School and the school's cheer team. So the F word, that expletive itself would not be considered a fighting word. But given the context of the message, and then also the second message, which is love how me and another student, this is redacted, get told we need a year of JV before we make varsity, but that doesn't matter to anyone else, upside down, slightly smiling face. That message is directly addressed to the particular student who made the varsity team as a freshman, and it directly places a judgment on the decision of the cheerleading coach she had texted with. In addition, in that previous text conversation, she had remarked, "That's stupid, but okay," in response to the coach's judgment of allowing the freshman onto the varsity team. So we can see here that she's directly making comments about the school, the decisions of officials at that school, and the operation of the athletics department. And so that addressing that part of the school, rather than the expletive alone, is what shows a significant disruption.
So if a student expresses public disagreement with the decisions of school officials, that is liable for punishment?
Now, that alone wouldn't be enough, but considering the unique facts of this case, specifically the school board policies and the agreement she assigned before she tried out for the athletics team, and the idea that, as shown in Vernonia School District v. Acton, by choosing to try out for a team, athletes voluntarily subject themselves to a degree of regulation even higher than that imposed on students generally. We can see that speech such as this could tarnish the image of the Mahanoy School District, as is against the athletics agreement that she had previously signed.
As Attorney Paolini, the Snapchat was online for 24 hours as it was posted to her private story. How would that tarnish the reputation of the entire school?
It's important to note that social media messages, they permeate very quickly to a large amount of people, and they can also have a certain permanence. Nothing you say on the internet can forever disappear, including the fact that discussion of her snaps spread throughout the school the following week, and that one of BL's fellow cheerleaders actually sent a screenshot of the messages to one of Mahanoy's 2 cheerleading coaches. So when the message, it may have disappeared officially in 24 hours, its effects still remained on the campus environment, particularly through the screenshots and the discussion of her snaps that spread throughout the school.
So,
Attorney Paolini, please define material and substantial disruption as stated in the court case Tinker v. Des Moines Independent Community School District.
So to address the material portion of that, it needs to be something that can be very clearly observed. So in this case, one perfect example of that would be the fact that one of the coaches was actually also an algebra teacher, and her class was disrupted quite a bit because students kept bringing up her posts in the class, which took away class time from other students who were trying to learn the algebra curriculum. And then to address—
well, given the example that you posed there, let's go with that. Had BL not posted F cheer, F the school, but instead had posted maybe some slightly contentious political takes, which would become the discussion of other students in the school, would she then be liable for punishment?
I think there is a difference there, first of all, because of the context of BL's case is that it was an athletics department and regarding the cheerleading team. And then second of all, because political speech is considered the most protected speech of any speech a student makes.
Well, what if she was talking about it? What if she was talking about a TV show and she said that she didn't like a specific TV show? And this was so contentious at the school that there was a nonstop discussion in every single class for the next 2 weeks. Could she be punished for her criticism of a TV show?
That would depend on how substantial the disruption would be, the response of the student.
It could be the whole school.
I think
everyone's talking about it. Everyone's talking about this take on the TV show.
I think certainly that could justify response by the administration, but that wouldn't necessarily be the same situation because, you know, she wouldn't have a cheerleading team per se to be suspended from. And because her criticism of the TV show wouldn't be directly associated with the school's ability to maintain its—
What if instead of posting F cheer, F softball on her Snapchat, she had posted something like F biology, F history? It can be assumed because she attends that school that she's talking about those classes in that context.
Yes.
Would that also be speech that, if disruptive to the class, you believe should be limited?
If it could be observed by school officials that the following week when she arrived to her biology class, that students were referring to her remarks about biology class and that the biology teacher had difficulty exerting control over the classroom and getting through the curriculum, then yes, that disruption would be substantial enough to take away from the equal educational opportunity of other students in the classroom.
You also mentioned how students being comfortable around this kind of post or speech causes disruption. So is this more about the students being comfortable, or is it more about the disruption being caused? And what exactly is this disruption?
I think it's certainly both. It's twofold. First, certainly that members of the cheerleading team, especially because they want to maintain a team-like environment, if they did not feel comfortable around BL because of her remarks or criticisms of the coach's judgment and of the cheerleading team and of the school itself, then that certainly is an important aspect of the case. But then second of all, the disruption to the classroom, for example, the algebra classroom, if that speech is such a significant disruption that it's taking away class time for other students, then yes, that is also relevant in this case.
Well, that's dependent on another's reaction to the speech, isn't it? Because if we're saying that if it's being discussed to the point that it's disruptive, I mean, any conversation can become disruptive to a classroom.
Yes, any student in a classroom, if they're, for example, shouting over the teacher, engaging in any behavior that directly contradicts the teacher's ability to be able to manage the classroom environment, and then that speech does have, the school does have jurisdiction over that speech. But I think what's important here is the magnitude.
Then once you step foot off campus, you have the same exact First Amendment rights as every other adult. So how is this censorship going to apply in school when it's not, she had no control over how disruptive it would be?
I think the key here is that in any case, you would have to prove a sufficient nexus to the school, directly referring to the school environment, directly addressing speech to members of the school environment, such as teachers, faculty members, other classmates.
But that line becomes blurry and it becomes sort of a slippery slope if you count any disruption to the environment that could be caused by any statement that a student makes. So how can you take that generalization and apply it in a case-by-case basis since it's so broad?
A key part of our argument here is that if we instead chose to have an on-campus, off-campus distinction from Tinker, especially in the age of social media, that consideration, that standard would be more arbitrary than the case of just looking at the on-campus effects of the speech instead of where the speech took place.
Attorney Paolini, with that, electronic squabbling amongst teens, high schoolers, it's fairly typical. So what would make this any different than the discussion of the same matter in person, rather than it just being off campus and during non-school hours? What distinctivizes the electronic squabbling and the in-person?
I think what you would have to look at is, how the fact that students were repeatedly bringing up their concerns about BL staying on this team throughout the week to the coaches, even students who were not a member of the cheerleading team. So I think you definitely have to take a look at the magnitude of the reaction. How many students had?
Did she plan for this type of magnitude?
It's uncertain what BL's intent was when she posted the message, whether she intended to have that magnitude of that effect.
So would you say that the disruption and the magnitude of it is defined by the time frame it took for this statement that BL said to kind of go away?
I would say that would certainly be a major factor.
So can you put a time frame? Was it a week before this statement went away and they stopped talking about it? Can you define that?
That time frame should differ in each case. I don't think it would necessarily be reliable. It would be arbitrary to try to pick a time frame that should apply to every single case in the United States. At that point, I think the discretion should be.
So then how would you measure the magnitude of the disruption?
I think that should be up to the determination of the school districts who are actually directly involved in those matters and have direct and personal experience with the school districts and with their school environments and how speech will affect those school environments. Now, Attorney Mosen will present the first argument in this case.
Earlier, you mentioned the nature of the agreement that BL signed. Do you have any specifics on that as to what the regulations were that she signed on to?
Yes, let me just pull that up. So the first agreement was an athletics agreement before she agreed to try out for the team. It remarks that students should have respect for their school, coaches, teachers, and other cheerleaders, and that they should avoid foul language and inappropriate gestures. Notice she used both foul language regarding the school and the cheerleading team, as well as an inappropriate gesture, raising her middle finger at the camera. The rules stated that
this was not a school-sponsored event, so how would this apply?
That actually leads into our first argument, which is that any off-campus speech should also be considered under the Tinker standard. So Attorney Mosin will present those arguments now.
Thank you, Ms. Attorney Paolini. So the first argument that I'd like to present today is that public schools have always disciplined off-campus speech to prevent on-campus disorder. And I feel like a very important point to make is the court case Lander versus Seaver. For instance, the Vermont Supreme Court upheld punishment of a student who referred to his teacher as Old Jack Seaver after the school day ended and on a street near the teacher's house, but within earshot of his classmates and his teacher. Because the student's speech had a direct and immediate tendency to injure the school and bring the master's authority into contempt by virtue of occurring in the presence of other scholars and of the master, and with a design to insult him, this incident fell under the school's purview. With this case, it's important to look at a few key points. The fact that this speech occurred off campus, however, it disrespected and insulted the teacher. In addition to this, the audience being
in
presented.
This case, in Lander versus Seaver, there is a clear direct at who this vulgar, this rude language is targeted towards, whereas in this case of BL versus Mahanoy, again, there is no mention of a specific team, a specific person, a specific coach, or even a specific school. So how does this really apply?
Yes, madam, I understand. So the thing with BL is that she already conceded that it was supposed to be and directly mentioning the cheerleading department and the cheerleading teachers. So with that, I'd like to move into the second component of my argument, which is that Tinker did not divest schools of their authority to regulate off-campus speech. Tinker ties school authority to preventing on-campus harm rather than the content of the speech. For example, students wearing armbands may have held a viewpoint unpopular to the administration, but this does not justify restriction of said speech. The student's speech was entirely divorced from actually or potentially disruptive conduct. And the decision of the court was based on the lack of on-campus harm and disruption. The authority to restrict speech is dependent on severity of on-campus harm and should not be considered based on the location of said speech. With this, I'd like to bring in the case Granite versus City of Rockford in 1972, which applied the Tinker standard to uphold restrictions on off-campus speech that substantially disrupted the on-campus school environment. This involves a violation of an anti-noise ordinance 100 feet from the school building, which distracted students. And the court rejected the notion that students, teachers, or anyone else has an absolute constitutional right to expression off campus in the immediate environment of the school.
Well, in both of the examples that you've given, not only was it quite literally very close to the school and within earshot of people at school or people from the school immediately, but in the case that we're discussing, this was on a private social media account. So, I mean, it's lacking the same immediacy that in the cases that you're referencing. You understand?
Yes, sir. So with respect to the immediacy of the speech, the reason why that's not as relevant as the magnitude that the speech had on the school is because regardless of whether it happens on or off campus, if that speech affects the school in a negative way, then it should fall under the Tinker standard. Now, in the third component of my argument is that closely related doctrinal contexts confirm that schools can regulate off-campus speech based on its on-campus effects. The school's authority over restriction of the Fourth Amendment rights have purposefully mirrored reasoning of the First Amendment. For example, a ruling in favor of BL could restrict the ability of schools to engage in reasonable searches. With drug testing, this involves testing drugs that technically were taken off campus. Therefore, a ruling in favor of BL could potentially contradict current Fourth Amendment laws, and if a substance in a drug was taken off campus, the on-campus harm is why the action needed to be taken. So regardless of whether the drugs were taken on or off campus, the effect and the harm is on campus, and that's why action would need to be taken.
Well, the effect and the harm that you're talking about, I mean, essentially came from word of mouth. I mean, the original posts were never actually seen by any teachers or coaches. It was the discussion around that. But materially, the initial post itself didn't do much else.
I think what the important thing is about this is that if you have word of mouth spreading between students, you inherently have a disruption of the school environment. And it's not simply something as saying that my biology class sucks. It's saying that the school cheerleading team is flawed. And by saying a sports team is flawed, you therefore compromise the integrity of said team.
So if BL had criticized the football team for losing, would this punishment apply? So if BL had posted about their football team going 3-0?
So the reason why it's more important as to why she referenced her own team is because her teammates are now afraid that BL.
Well, let's not talk about her teammates. Let's say it was the school. It disrupted the school, and discussion of it disrupted classes.
Right. Could you repeat your question, please?
So the speech, discussing, I think the football team sucks. I think the basketball team sucks. And if the students had discussed it in a similar way, would she then be liable for punishment?
It really all depends on the magnitude of that discussion. Now, if that discussion was simply saying that the team isn't doing well or underperforming because of the score they received, then no, that wouldn't be subject to any type of punishment. But if that speech was directed at someone and could potentially cause harm, then action would need to be taken.
But then how is this directed at someone and could potentially cause harm? Because I do not understand how this could have been directed to someone if it just said F cheer team rather than the one specific person.
Right. So when it's directed at the cheer team, it's directed at all of her teammates in that cheer team. And in a cheerleading team, cohesion is very important within the team. So, for example, one of the famous things that cheerleaders do is the big human triangle. Now, what if teammates don't trust BL enough to perform specific things that cheerleading teams would do?
What if a student had stated the same thing but wasn't on the cheerleading team? Would that then justify for a different repercussion because she wasn't on the team and it wasn't her teammates? Or no, it would be the same situation?
So since if a student hypothetically was to say a speech which would disrespect the cheerleading team and wasn't specifically on the cheerleading team, the punishment for that student would be less severe in the sense, assuming that the magnitude of disruption was the same, because you're taking out the aspect of cohesion within the team. However, if the disruption is still...
Are you saying that any gossip that's critical of a school team where someone is part of that school team would be grounds for punishment in the future if this case is ruled in your favor?
No, in short terms. And what we're basically trying to get at here is I can call my biology teacher bad because we all failed the test, and that won't subject me to punishment because that is free speech. However, if I directly harm or threaten to harm or cause something where students feel unsafe in the learning environment that they're in, then that brings in problems.
Well, there was no intent expressed to harm anyone. There was no intent of I'm gonna drop somebody when we're doing the triangle. And certainly if they wanted to address that, removing her from the team was probably not the way to go about that. But to go back to another example, you talked about the magnitude of the speech. So is any speech, regardless of the how inane it is, could be punished if it spread around the school?
If it spread around the school but failed to disrupt the educational environment, then it would be allowed. But in this situation, we're having a disruption of the educational environment, and trust within the cheerleading team is being compromised, which calls for action.
Attorney Mosen, I'd like to shed light on the decision in Chaplinsky v. New Hampshire in 1942. what is the school district's stance on fighting words? And do you consider BL's words in the snap to be fighting words? Please explain.
Attorney Paolini would love to cover that section. Thank you.
So the expletive alone itself would not be considered fighting words. BL's speech in general would not be considered fighting words. The problem with the speech would have been her goal to undermine team morale and chemistry and the effect it would have had on class later on. A student doesn't need to.
Where did you come up with that idea for that was the motive of the post? It seems to me, and it seems from the statements that have been released by BL, that it was an adolescent post made out of rage in a moment of annoyance. So how do you understand?
BL herself did not dispute this fact that her speech would undermine team morale and chemistry. We rest our case.
Thank you. We will now hear argument from the respondents, Attorney Reed and Attorney McCann.
Chief Justice, and may it please the court. Despite what the petitioners have said, we will make it clear today why the court before us should uphold the decision of the lower court. What happened was quite simple. BL was a high school student having an emotional moment on a popular social media platform, Snapchat, which she was punished for. I will present our first reason regarding disqualifying speech content, and my co-counsel will present our second reason of disqualifying speech environment. I'd like to re-illustrate what was said for everybody here today. F school, F softball, F cheer, F everything, followed by love how me and another student got told we had to do a year of JV before we made varsity, but that didn't matter to anybody else. Those words may be inflamed and emotional, but they do not qualify the school's infringement of BL's right to speech. The student handbook does allow for the school to regulate school speech and within the context of a sport, but her Snapchat post occurred out of season and therefore does not permit the school from disciplinary action. And secondly, in the case of Tinker v. Des Moines, in which the precedent was set that if speech materially disrupts classwork or substantially disrupts order, it can be regulated. There is no actual legitimate metric of disruption that BL's words have said to have caused, and therefore there is no way that her words can qualify from that, because as it seems right now, it is up to the teacher's discretion. And my co-counsel will present our second reason.
Yes, our second reason is the disqualifying environment of the speech. BL's Snapchat post took place on a Saturday during a shopping outing, not under school supervision and not in school-affiliated clothing. This invalidates the school removal of her from the cheerleading team for her sophomore year. The Mahanoy area high school cheer team argued that BL's words violated the cheerleading respect provision and therefore permitted her removal. The provision states, please have respect for your school, coaches, teachers, other cheerleaders, and teams. Remember, you are representing your school when at games, fundraisers, and other events. Good sportsmanship will be enforced. This includes foul language and inappropriate gestures. A reasonable person would conclude that the rule is in relation to sportsmanship that explicitly involves the school or school game, not off-campus speech during which the cheerleader is not in uniform representing the school nor performing. The application of this sportsmanship rule to an instance that involves no performance of at an athletic event just reinforces the obstruction of BL's.
This same cheerleading handbook code of conduct also says that, quote, there will be no toleration of any negative information regarding cheerleading, cheerleaders, or coaching on the internet. So how does this post of F cheer, F school, F everything not directly violate this code that BL agreed to before joining the cheer squad?
Yes, and so the way it doesn't impact that is that it's not during the time where these rules would be enforced. This is before the season, as we stated before, and that these rules cannot apply to her if it's not in season or at a schooling event.
And I'd like to just echo my co-counsel's point there, because a lot of the words are being portrayed as sound bites when in totality, the words are portraying from these provisions of the cheerleading respect provision. The words themselves talk about a direct correlation of the words and behavior and the actual sporting event at hand. And so for the cheerleading team to overextend itself to a period of time where BL technically is not even a cheerleader is just an overzealous act. And it does, because it is beyond the appropriate.
You mentioned that this happened at a time when cheerleading season was not in session, but it's clear that BL's post tainted the spirit and the dynamic of the Mahanoy cheer squad, as we know from the visible upsetness of many of her teammates and her coaches. And this led to division and tension among teammates and the teams. How do you understand a substantial disruption within the school to be defined? And do you not believe this to be a substantial disruption?
I do not believe this event to be a substantial disruption because, one, we're talking about cheerleaders and we're talking about cheerleaders that are teenagers, and cheerleading is a very competitive sport, evidently speaking, because BL's whole frustration stemmed from the fact that she didn't make the team, but she wanted to. And because these are teenagers we're talking about, very emotional, very expressive human beings, I feel like her words were not intentional in trying to cause an unnecessary amount of disruption, because the lower
Frederick claimed that this is an emotional outburst that many teenagers, they feel this way, and she said it and she didn't mean to cause any harm. But how do we as justices make that distinction between an emotional outburst with nothing behind it versus, for example, hate speech? Or let's say if she made a threat against her coach, but would you want us to also take that as an emotional outburst versus something that would cause substantial harm? So how can we make that distinction, or how can we, where do we draw the line?
Thank you for asking that question, Justice Thomas, because sorry, I do think it is extremely important that this distinction is made and that we understand where emotionality stops and where other things begin. And I think where the emotionality is really where it is hinged upon in this case is when in the string of words, F school, F softball, F cheer, F everything. I feel like the past part, the last part that I said, F everything, is really reflective of the emotionality of this post. Because if it was indeed a post that was supposed to
Attorney Reed,
effects, why would she talk about to life itself?
I would like to switch gears for a second and just gain an understanding for the precedent that would be set through the support of beyond this decision with regard to the school's control over bullying and harassment outside of school grounds. And so, to put it simply, what control would the school have over bullying and harassment occurring outside of school grounds if they can't control such a simple case of vulgarity towards the school?
I think that oftentimes, and even the petitioner is trying to portray this case as a case that is going to disqualify the school from taking any action of off-campus speech, and it's going to limit the school's capacity to regulate itself and the health of its students on campus, even if things occur off campus. And I don't really agree with that. And the way I say this relates to bullying is that one can understand that bullying is a material and substantial disruption to the school environment. It is a tailored experience, a harmful experience that is targeted towards one person, one individual over an extended period of time. That is what bullying is. This one-off event of general angst at life in the wake of a teenager not making a sports team she really hoped to have made.
But didn't she call out the other students that had skipped a year and went straight into varsity? So isn't that something that, is tailored to one student, aka the person that made the team and when she had not?
Could you repeat that, please? Sorry, you were cut out in the beginning.
I was asking about the fact that didn't she also make statements and claims about the student who did make the varsity team, who was an incoming freshman, and wouldn't that qualify to your definition, since this was, you can also argue, a tailored, statement towards one person and not just general angst at life.
I'm glad you also asked that question, Justice Thomas, because the petitioner did say in the beginning that the redacted student in the following comment, love how me and redacted student got told we need a year of JV before we make the varsity, but that doesn't matter to anyone else, upside down smiley face. The petitioner falsely said that the redacted student was the student that made varsity. In fact, that redacted student was another student who was told that she needed to do a year of varsity before junior varsity before she had to make the varsity team. And therefore those two individuals were sharing their angst amongst themselves. The two posts that are in question today do not explicitly target anybody by name.
The Snapchat was private and she had specifically chosen who would be viewing that. So who's to say whether or not she was targeting something, as she did know that there were cheerleaders who would be viewing the story?
From my understanding of Snapchat and making private stories, one can make their private story at any time, and the people who have been added from previous days until they're removed can see whatever content is posted on that private story. And because these are all cheerleaders, they're all running in the same circles, teenagers like to share their information and socialize. I do not think that just because it was posted on a private story and then there is a targeted audience, that means it was a targeted message towards that audience. She could have previously added those people to her private story. So it is not to say that she knew exactly who was on there and she wanted to, because there's no correlation between who was added and then what time elapsed before she made the post.
Attorney Reed.
Individuals with her this entire time. Yes.
Attorney Reed, while she may have added those individuals to her private story before the incident occurred, she still made the choice to post on her private story and not her public one. Therefore, it feels obviously as if Snapchat was targeted at those cheerleaders. Is it not then targeted at those cheerleaders?
I would not say so, because her private story was not only strictly cheerleaders, it was whoever else. It could have been her cousin, it could have been her sister, it could have been individuals she thought were close to her. And the distinction between public and private is probably because she was aware that her school would be wielding this unnecessary power over her if she was to post more publicly and more people would see it. And even in this private context, her school still managed a way to try and infringe upon her First Amendment rights. So this distinction between public and private is not targeting, because there are 250 on there people within this private story, and therefore she could not be talking to everyone, because everyone does not apply to the words that she did say.
Attorney Reed.
I would like to go back to the argument made in regards to bullying and harassment, and I'd like to point out that bullying doesn't necessarily have to be a material harm. What if BL had stated F a particular individual, F some people on the team? What is the difference, and can you explain that?
The difference is that individuals were named in particular, and therefore, because these individuals were named, and whatever environment that happened before or after, that could constitute a different action. But because these words are so generalized, I do not think that using this very generalized emotional case as a vehicle to talk about how bullying may be upheld if this case rules in our favor is invalid. And bullying has to be proven to be a pattern. It's a pattern behavior. It's a targeted pattern behavior. And that's what constitutes bullying, from this, an isolated emotional squabble or harassment event between two individuals. And even if she did name one individual within this short time period of just angst and upset because she didn't get to the team she wanted to, this is not in and of itself a patterned behavior, and it lives within this isolated event. And in this hypothetical, I cannot give you a clear answer, because I wouldn't know all the parameters and what harm was done to these individuals. And right now, I do know that there was not any material or substantial disruption to her school environment other than what what one can assume can be the gossip of the week, or electronic cheerleading squabble, which the lower court has conceded is a very frequent occurrence at the school. So I do not see this event in and of itself being out of character or in any ways excessive.
The Vermont Supreme Court case Lander versus Seaver ruled that a school was within its right to discipline a student for off-campus speech because that was language used to other students to, quote, stir up disorder and subordination. It seems to me as though an attack on the team and on the sport of cheer and of softball, especially in a private story where there are teammates, would serve to stir up disorder and subordination within the team. So can you explain the justification for this language?
I would first like to point out the fact that Lander versus Seaver occurred in 1859. And while these precedents are very important in how we decide our cases, not only was this precedent stated in a time that is so unlike our own, we're talking about Snapchat, but also because this was decided the language of that Lander versus Seaver case was narrowly tailored to the school cultural and social difference to today. I do not think that this case is a great vehicle to parallel our case, which is again very generalized, very emotional, and this case, which is very tailored and
continuing on, I have a question for Attorney McCann. What degree of responsibility do you believe the Mahanoy Area School District should take in or has taken in enabling BL's words to permeate into class time, even though those words were outside of school, into disrupting class time?
So what I believe the school action that they should take is that the school should, if it was clear that the intention of this was to disrupt the school, which it was not, I believe, as my partner previously stated, that it was mostly about her frustration and her feelings during that time, and her just letting out how she felt on her own. And as we also mentioned that it wasn't pointed directly at a person and wasn't meant to cause an uprising. And so in this case, especially, it shows that that the school shouldn't have any hold over this particular situation, at least.
Attorney McCann, given that the post had profane language that was directly pointed to the school and the team, subsequently causing disorder, to what extent do you believe that the school has no say or punishment toward BL's actions?
I would say as that it wasn't pointed towards the school. It's never directly pointed at the school. And what it is basically saying is that she's saying F this, cheer and all these things. And she never once says the school's name. She never shows Mahanoy Area High School's uniform or school logo in any of this in the Snapchat. And therefore she isn't responsibly naming somebody out.
Well, was it not earlier conceded that BL understood that the audience would understand the reference to the school?
Yes, it was, but basically it's that it would be referenced towards the school, and sure, but you have to remember that this is in a time of her being extremely upset and disappointed because of false information that she was fed. She was told that that they needed to be a part of the JV team to go to the varsity team, but that standard wasn't held for all of the cheerleaders. And so her being upset in this was right of her to be. And so understanding this, you can see that it wasn't like it was an emotional response to something that happened. And so yeah.
And I'm sorry, Justices, I'm back. My internet did cut out, but I would also just like to echo my co-counsel in that the words, even though they're generalized, they can fall under, the literary terms synecdoche, monetomy, and that they can be representative of something greater. In this case, the school that she was attending at that time. But I would also like to echo my co-counsel in saying that because she did suffer injustice and she was given false information and she witnessed another person benefit from something she was denied, just goes to show that her angst and her talking about the school, even though she did not do so in particular and with very narrowed words, even if it was in reference to the school, she is exposing a policy that was falsely given to her, and therefore, if it did relate to the school.
Well, she didn't mention specifically the policy.
Sorry, Justice, could you repeat that?
The policy that the information that you're referring to that she was given incorrectly was not referenced in the actual message.
The information actually was in the two posts that happened after another. The second one reads, "Love how me and another redacted student got told we need a year of JV before we make varsity, but that doesn't matter to anyone else, ? Upside down smiley face." So she actually did reference the injustice that she did face and the false information she was fed. And so if you were to take those two posts in sequence, you could even argue, even though she does not explicitly name any individuals, she is passively expressing the injustice she did face, and therefore
Attorney Reed, but aren't we in this court today discussing her speech and how it impacted the school and the amount of censorship that we can allow to student speech? Are we not talking about that rather than the actual event of injustice that happened? So how is this applicable to this case?
I was only responding to that because the previous questions were asking about the content of her injustice, and Justice Breyer did ask me whether or not she did name this injustice, and I was just relaying that it was. But you're completely right, Justice Thomas, in that we're talking about whether or not the school has the right to modify her speech or discipline her based off her speech, and this is incorrect. They do not have this right. Because the materially and substantially disruptive statute precedent that is set by the Tinker v. Des Moines case, there is no metric, there is no measurable impact that can even be drawn from this case to even apply this Tinker case to the BL versus Mahanoy area school district.
So if we can't apply the Tinker case to the BL case, then we can apply the Frederick v. Morse v. Frederick case, which is also referred to as Bong Hits for Jesus, which students did line up on the other sidewalk across the street and held up a sign that said Bong Hits for Jesus. And so the case came out to say that that schools can regulate how much speech is censored. So how is this case therefore different?
This case is, the Morse v. Frederick case is also a poor vehicle for this case, because when this event occurred with the Bong Hits for Jesus sign, it occurred at a school supervised event. And therefore there was school interest, there was school representation, and the words that the students reflected were in conflict with the school, and therefore the school had the ability to discipline the students in that context. Even all of the provisions and all of the handbook guidelines that are being used upon BL in this case apply to on-school speech and school-related events. And so you could see in both cases, because they took place, because they're relating to on-school speech, BL's speech took place at a shopping mall with a friend, the Morse v. Frederick case does not relate to this case and cannot be an adequate parallel to this case. And therefore, through that case, we cannot allow the school to limit school speech off school grounds because shopping was not a school-sponsored event. It was a personal one.
Attorney Reed, I'd like to get your stance on the same question I asked of your co-counsel. What degree of responsibility do you believe the Mahanoy Area School District should take in or has in enabling BL's words to permeate into disrupting class time and the stance of, their culpability?
I think that the precedents and doctrines that exist today, if those were correctly followed, would be the best way for the Mahanoy Area School District to handle BL's words. Because the lower courts, as per the lower courts, electronic squabbles were a common occurrence amongst cheerleaders. It just goes to show that this event in and of itself was nothing out of the ordinary, and therefore for the school area to pivot it and turn it into something out of the ordinary just goes to show how it is an overextension of the school, which leads to an inhibition of BL representing her free speech. And I would also like to say, and I understand schools have a very important interest in regulating their environment and facilitating education and health for its students. And the doctrine of in loco parentis is very valid. However, during this time, BL was within the care of her parents. And I feel like even if this was a school-sponsored event or it was an event that pertained to the school and it had some authority over BL through this in loco parentis doctrine, there would be a case for that. But since she was in the care of her own parents, this overextension by the school is invalidating her parents' responsibility to take their own personal disciplinary action to their child. And it's an overextension and an infiltration of their parental right over their child. And evidently that is why her parents felt the need to challenge this in court, and which is what brings us here today. I would also like to reiterate, before I was cut off because of my internet, the cases I was referring to were Schenck versus United States and Brandenburg versus Ohio, in which a clear and present danger test was established and inciting language was prohibited. And I would just like to say, because of the generalization of BL's words, she does not qualify under those two precedents either, because it was non-threatening, it was non-inciting, because she said F everything at the end of her first post. And obviously, one cannot threaten life itself. One cannot incite an incident with life itself. That in and of itself represents the pure emotionality and the upset BL was experiencing within that event. And therefore, they do not qualify under those two precedents.
Well, does the emotionality you bring up not in some ways provide an argument towards the opposition of, especially as we've discussed, that this message was very widely well known by the students. It was disrupting entire other classrooms. So, I mean, it would seem that the emotional nature of the argument was the reason that it was able to spread so far. No.
Well, this is just the general nature of social media, and I do not think that her content in of itself is the fact that it did spread to so many individuals in and of itself is disturbing, because those individuals had to consent to be a part of BL circles, and therefore they wanted to see what she had to say and she had to post. And I would just like to quote a part of the opinion of the Cohen versus California case, which states, while the particular four-letter word being litigated here is perhaps more distasteful than most others of its genre, it is nevertheless often true that one man's vulgarity is another's lyric. And I feel like that speaks to what BL and emotionality I keep perpetuating throughout my case here today. Because of the emotional spirit, it just goes to show that what is being expressed here is not a targeted attack. It is BL's lyric of sorts. It is the way she is conveying her frustration and is nothing more than a harmless teenage emotional outburst that could have been handled a lot more gracefully and compassionately by the school instead of compounding her upset by not only giving her false information, but then therefore taking her away from a team unjustly. And I would just like to go on and just reiterate that we live in a digital age, and there's an estimate by the Pew Research Center that 97% of teens 13 through 17 use a form of social media. So it is safe to say that BL is not the only student who has expressed themselves online and who has been able to socialize online, and especially during a global pandemic where we are not able to hug our loved ones and talk to our loved ones in person. And because of how great the digital space is for these young individuals, for a school to enter those spaces, for them to be free and expressive and form their own communities, is just setting a precedent that the school will be able to infiltrate on these expressive, lively spaces that young people have made for themselves. And I would also like to go on to say that we should not be compounding personal emotional episodes with the infringement of student rights. And that would be what would happen if you were to counter the lower court's decision, because precedent has shown us that BL speech was protected by the Constitution, as it fails to qualify as unprotected speech under said precedent. And therefore, precedent has shown us that her removal from the cheerleading team due to her speech was a violation of her First Amendment right. We are in a digital age today, as I said, and we will be in one tomorrow. And in order to maintain our democracy within the changes of this world, we must maintain the very principles we have founded it upon. And this will take place.
Earlier, you mentioned the statistic for the percentage of teenagers who use social media. Does the level of integration that these platforms have, I mean, with the school environment, it would seem, especially in how discussions on that platform very quickly moved into real life. I mean, this is a new area that needs to be regulated. Why should it be regulated in this way?
I would just go on to say that I think the Tinker v. Des Moines precedent is the perfect precedent as the perfect vehicle for every online interaction. And what we're essentially trying to talk about today is that Tinker v. Des Moines, because it is not a materially or substantially disruptive event that would occur today, does not hold in this case, and therefore isn't applicable to this case. However, the precedent that case set is perfect for paralleling online and off-campus, online speech, off-campus speech, and their impacts on school grounds. And I think that because we have this precedent, we have a way to litigate digital platforms with our teenagers. But today, Tinker v. Des Moines does not hold with BL speech. And I thank you, Justices, for your time. And I urge you to remember that any steps against our rights today are leaps against our rights tomorrow. And we rest our case.
Okay, well, that was extremely well done, students. And we're going to have a couple speakers who are going to have a few words, and then we'll let everyone sort of come out and congregate. The Zoom technician, I need you to turn on my camera so I can have my video going. Okay, well, I'm not sure why the Zoom is not allowing me to turn my camera on, so you'll just have to imagine me. But we're going to have a couple guests speak now. So we have Mary Beth Tinker here, who you might have recognized the name from the arguments today. And yes, it is the same Tinker as in the case, or one of two actually. And we also have State Representative Michelle here, who will have say a few words too. So if Mary Beth, if you're you should have been given the ability to turn on your microphone and your camera, and we'd love to hear your thoughts.
Hello, everyone, and thank you, Mr. Morez, for inviting me today. I can't turn on my video because it's saying you can't start your video because the host has stopped it. But I'm glad that I was here because you all did such a wonderful job. Good going. And I want you for my lawyers, Attorney McCann and Attorney Reed. You were so great. I loved your arguments, and the Supreme Court justices were really great also. So good job, everyone. I'm sorry I was a little late. So I might have missed the school board arguments, but I'm glad it's recorded because I'll have to listen to those later. But I learned some things about the case, and I thought you all were just great. And I loved your points about the very last one, steps against our rights today are leaps against our rights tomorrow. And there were some really important points that you brought out about the emotionality of it and how, that's very important because we need to be able to express our emotionality. And that's a very important part of life. And that's what she was doing. And then the idea that an injustice was done. I was really glad that you brought that out because the more I think about it, it was such an injustice because what did she do? She expressed her feelings at a quick shop with her friends using a commonly used word of our culture to express feelings. And for that, she was punished and taken off of the cheerleading team and kept away from something that was really good for her. And that's one of the big injustices of it. So I'm really glad to be with all of you. Thank you for inviting me. Good job. And I'm looking forward to listening to the live the C-SPAN coverage of at the court tomorrow. I'm going to tune in. Are you all going to tune in? Because I'm going to listen. I expect to hear a lot of these same arguments from the justices and from the ACLU attorney. Yeah, it's going to be quite interesting because their attorneys are really geared up. And all these cases that are at the Supreme Court for student speech, whether it's Bethel versus Frazier, Tinker, Hazelwood, Bongans for Jesus, they've all been ACLU cases, and now this one as well. So it's going to be very interesting. Thanks everybody for inviting me. Good work.
Thank you for coming. And State Representative Michelle, you want to say a few words?
Can you hear me?
Yes.
Okay, good. I've been having very bad connection problems. Wanted to thank everyone. I'm also in another meeting that started 20 minutes ago now, where I'm supposed to speak at the moment. But thank you so much. This was an amazing experience. I'm actually going to be at an ACLU event tomorrow, and I'll make sure to mention the experience tomorrow. But again, thank you very much to everyone. It was a pleasure. I've been having problems with the internet myself now, so it's difficult to manage the two meetings, but I appreciate everything, and this was fun.
Okay, so we're going to promote everyone now to panelists. So if people want to have conversations and whatnot, they're free to. It might be a little chaotic, but also you could use the chat if you want to send any messages to any particular individuals. It's really been a pleasure working with these students. They're a really bright bunch of students, very articulate. And I also want to recognize the students who didn't have speaking parts today, but played an important role in contacting the media, contacting our guests, and also doing the technical stuff with Zoom and so forth. So thank you all as well for doing a great job today. Does anybody have any questions or comments they'd like to address to the group?
I would like to ask a question to the group. What students, what do you think about this case? I mean, are you concerned about it? What do you think should happen? The ruling is coming in June. So what are your personal feelings?
I know when Attorney Mosen and I were going over the case, we had some difficulty coming up with arguments because, as students in school engage in social media in the age of social media, a lot of students will express their thoughts off this. And as students, we do feel like our free speech, First Amendment rights are important. So I think we both, and I don't want to speak on Mr. Mosen's behalf, but both felt that this ruling is going to be really important for maintaining those free speech rights of students when they are off campus.
As we were creating the case, we were kind of just joking around about how this even made it to the Supreme Court because, just like the magnitude of the situation. But I feel that the court should definitely rule in BL's favor on the basis of free speech. And I'm glad that it's getting the traction that it is, because it really does set some sort of precedent for, the freedom that students would have. So I'm really glad that we had this opportunity today, and I'm excited to see the reports tomorrow.
I know it's really interesting because I was feeling pretty pessimistic about the chances for Brandy Levy. But then yesterday I was on a video call with this group called Student Voice, which you all should get involved with. It's really amazing. It's a national group and they're doing stuff in Kentucky, Atlantic, all over, and you can get involved too. But so they had an attorney, Frank Lamonte, on there, who's a First Amendment attorney, and he said he's feeling pretty good about the case because there are all these, and these students had even filed an amicus brief themselves. But he said there are so many conservative groups, there's something like 24 amicus briefs that have been filed on behalf of Brandy, and many of them are very conservative groups, which I know from my experience that there are a lot of conservative people who do want youth to have rights also. So maybe there's a possibility. Are you all going to listen tomorrow?
I know I'll definitely be there. Something that we discussed as a class from the beginning was that this has a lot of holding on the lives of students, as you said, and also just the chance for this to be almost like a landmark case in which we've studied throughout the whole year. So I will definitely be listening.
Well, yeah, you're going to be there, Justice Sotomayor, because you have to be.
Of course, in spirit and as Justice Sotomayor.
Exactly. So you're going to listen. Are the rest of you going to listen tomorrow, or are you going to wait for the recorded version?
I am. Sorry, I don't know who else is talking. I just think it'll be very interesting to see or hear what arguments they come up with compared to the arguments that we came up with, and see how how we thought versus how they thought, and how it went.
I know that's going to be really interesting, especially for all of you. I mean, you're so steeped in this case. You've learned all these details about it. Things came out that I didn't know, like exactly how many people were following her on Snapchat, the fact that it was the public versus private, and she put it on the private, things like that.
And I don't how I think, if I'm going to be very honest, I'm a very like, I don't know, kind of reserved individual, and I don't really look a lot into, before this, I didn't really look a lot into Supreme Court cases and the precedents set cases, and being a part of this project, as part of my grades, Mr. Morris, I hope this doesn't affect my grade, but being a part of this project really made me see and identify like how profound these arguments are. And I feel like as a young person, and your rights kind of end where your knowledge of your rights end, and allows people to take advantage of you because you don't really have anything to protest. And I feel like now I'm going to be a lot more intentional about looking at the courses that the cases that are taking part in the given moment, because I think it's just really fascinating to see where kind of like the pulse of the rights of the United States kind of fall at any given moment.
I know, you are so right, because that's why I tell students, your rights are like your muscles. If you don't use them, you can lose them. And in order to use them, it's good to know them. We have to know them. It's a lifetime, thing to learn all these rights. But yeah, a group that really, there's so many groups that care about your rights in various ways, but the American Civil Liberties Union, I'm on the DC affiliate of the ACLU on the board, but they've been very involved with racial justice issues and issues, right? They have a lawsuit right now with Black Lives Matter of DC because the police were supposed to be giving information about how many stops they've been making and who they were stopping and things like that. And so they weren't providing the information. So the ACLU joined up with Black Lives Matter of DC to have this lawsuit. So, there's just such a variety of things that they do. A lot of it does have to do with youth rights, immigration rights, racial justice issues, so many other things. And a lot of them, they intersect. It might involve more than, one issue, that usually does.
Yeah, I thought that point that was made earlier about how, I guess it was Attorney Mosen made the argument that if we restrict free speech, then off-campus free speech, then we could also infringe on students' Fourth Amendment rights off campus potentially.
Mm-hmm.
I thought that was a really interesting argument. I'll be curious to see if how big of a deal that is in tomorrow and in the eventual decision.
Yeah, that's very interesting. That's sort of creative thinking there, Attorney Mosen. Good going. You're certainly right.
My name's Tavish Whiting, and I'm from Lee Summit North High School outside of Kansas City, Missouri. And I just want to say that, and I was invited by a young lady named Monica, and I'm afraid to pronounce your last name because I'm going to screw it up. But I just want to say that I'm just extremely impressed with all of you with this court case. Very excited about it. We've got a lot of students out here in the Midwest that are going to be watching or listening, I should say, to what's going to happen tomorrow. This is a very, very important free speech case. We actually have a teacher here at our high school. She's a math teacher. She was the junior editor of Hazelwood East, the Hazelwood East High School newspaper, which was the famous Hazelwood v. Kuhlmeyer case. And so she's going to be in my classroom tomorrow listening while we do this. But I can't, in my experience with case law and studying the history of the Supreme Court, I truly, honestly believe that this is going to be a big landmark case, a free speech case. And being a coach, I've coached here at this high school before. I do understand that, a lot of coaches here are pulling for the school, but then you also have to take into account that the freedom of speech is a paramount freedom that we enjoy in this country. And I'm very anxious to see or hear, I should say, what's going to happen tomorrow. But the big thing is, you guys did a fantastic job, and I really appreciate you all inviting me to listen in on your case.
Thanks, Tavish.
Who's the person from the Hazelwood case? I'm just curious, Mr. Whiting, who's going to be with you tomorrow?
Well, I was afraid you were going to ask that. Her name is Tracy Reisinger.
Oh, okay.
But I apologize. I do not know her maiden name.
Art, it might have been, let's see, there was Leslie Smart, Kathy Kuhlmeyer. I can't remember. But anyway, I don't want to take up all of your time, but that's great. That's going to be interesting. I can't wait to hear how that happens. Write to me. Any of you also can write to me. I'm going to put my email address in here, tinkertour@gmail. Yeah, write to me and let me know how that.
Thank you very much. Appreciate that.
Okay, does anybody else want to say anything before we wrap this up? Any parents or other spectators?
Yeah, I just wanted to talk about as I researched into this case, I definitely came to understand how much of an important precedent it was setting. I mean, not even just with free speech, but specifically because it involves social media. I think it's an important case in that aspect because it's going to be making a specific ruling on speech that was done not only off campus but online. So it's kind of watching the law catch up with where our lives have been.
Yeah, it was kind of interesting for me to see too, as one of the research assistants and having to do so much and like looking for, for facts or other cases that could be used. It was really interesting to see how many other cases I didn't know about and, how much precedent was set prior to this case that I didn't know about either.
Yeah, I agree with Kayla too, in that fact that going through and like looking into some of these cases and seeing how they all relate and how honestly a little bit dated some of them are. And so now that the fact that we're coming up with these that apply to social media and how, because it's the main vehicle of communication for our generation now, and no matter what happens in this case, it's directly going to impact each and every one of us students going forward, especially for years to come. Seeing all these different cases and how they were ruled on, it was definitely really interesting to see.
Honestly, I'm extremely anxious to see what justices are going to say about this case because as like justices, we prepared so much and did research on our own justices and see their views and how it is that they would rule. So I'm especially interested to see how it is they're going to rule on this case.
So how do you all think it's going to come out? Who thinks it's that BL is going to win?
I think BL has a pretty good chance, especially considering that the speech was conceded to be off campus. I think that's pretty big in deciding this case.
Who thinks the school will win? School will win?
I actually think the school's going to win. When you look at the erosion of student rights that's taken place since 1969, it's pretty much gone in one direction.
Yep.
I know a lot of these justices ruled on, some of the earlier cases like Morse v. Frederick and Earls v. Oklahoma. I just would be really surprised if that direction changed. And if it were to change, it would be very impactful. You would have a really cut back on what public schools can do with their students, which, I personally would like to see students have more freedom, because when you take away their freedom, then they don't learn how to exercise it, as Mary Beth said. But I am a bit skeptical that the court's going to side with BL on this.
I hate to say that I kind of have the same feeling because, well, Clarence Thomas, we know he's not going to vote for students because of what he said in the Bonghits case, that students don't have any constitutional right to free speech and that Tinker should be overturned. And then even Sotomayor, she voted against a student in, was it Connecticut? I think that was the Avery Donninger case where she had students call the principal to, quote, piss her off. She lost, and Sotomayor voted against her before she got on the Supreme Court. And then, well, I don't know. Alito, I'm not sure what he'll do, or Roberts. Alito, there was a big event at the Supreme Court, and I know you all want to go and have dinner, but there was an event at the Supreme Court in 2013. The Supreme Court Historical Society featured the Tinker case, and it was a very conservative organization that hosted it, the Liberty Institute. And so my brother John and I went, and at that time, and Alito was there, he hosted it also. So after the program, I went up and asked him, I said, well, Justice Alito, I heard in your Senate confirmation that they had, that they had asked you about the Tinker ruling and whether you supported students' rights. And so if Tinker came to the court again, would you support the ruling? And he said, well, I guess I would, because I do support students' rights. But he has also voted against students' rights in the past. So it's kind of, I don't know what they'll say, but there's certainly a feeling among many conservatives that they do want students to have free speech rights also. So, but I've been so glad to be with all of you. It was very interesting. You did excellent work. I want all of you attorneys for my attorney if I ever need one. And thank you to everyone for including me and inviting me.
Okay, well, I think that's a good stopping point. So thank you very much, everyone, for coming. And, we'll send out invitations next year. We'll have our 7th annual Moot Court. It'll be a different case. And hopefully some of you will be back to see that in person. We do record the audio of our Supreme Court, just like the real Supreme Court. So it always is made available on YouTube each spring. So again, thank you everyone for coming. You're free to go. If anyone wants to stick around and talk more, I'll be here for a little bit longer.
Good night, everyone.
Yeah, I'll send out the YouTube link to everyone that was on the invitation lists.
If I may ask, I know we're in COVID. Have you done this before in person, in a chamber, or has this always been a virtual format?
No, the first 4 times we did it was in person. And last year we did it on Zoom, and this year, obviously. So the preference is to do it in person. But, there are some added advantages of doing it on Zoom. We got to have you and Mary Beth and some other people. And of course, some parents too, who might not be able to physically drive to the school, were able to attend. So there are some trade-offs to this format. It's going to be interesting after the pandemic is over to see how much we do events in Zoom and how much we do them in person, because there are some benefits to doing it in this format. And the biggest one I see is that I can have someone from Kansas City or Washington, D.C. attend.
Well, I think it's wonderful. Yeah, I mean, this is a good thing that's come out of COVID. I run our youth and government program here, and some of the youth and government conferences throughout the country, they'll have it posted on, they'll have video of it, and then invite people to watch the video or to participate that way. So kind of a hybrid, we're going to do it in person and invite people through Zoom. So I hope you do that again in the future, because it's fantastic to hear. I wish I had students here right now to have heard this. This is fantastic. Loving it.
Thank you. We're going to be closing up the Zoom momentarily.